University of Technology, Mauritius, and Gopeechand.
You may sit down. In Mauritius, you may sit down. And in fact, from the point of view of the camera and the microphone, it is a great deal easier if counsel in Mauritius address us sitting down. You may find that uncomfortable. I know counsel like to be on their feet, but from our point of view, we won't be able to see you if you're standing, and we may not be able to hear you. Can you hear me all right?
Yes, Your Ladyship.
Good. Splendid. Miss Deal, if you would prefer to sit down, you're welcome so to do. Thank you. Very well. The other thing that I'm asked to say is that if any member of the board wants to ask a question, I'm going to ask them to raise their hand so that you know that there is somebody asking a question. Good. Mr. Chetty.
Your Ladyship and Your Lordships, I appear together with my learned friend, Sir Yashley Rittle, for the appellant, instructed by Mr. Robin Lloyd. My learned friend, Miss Deal, appears for the respondent, instructed by Mr. Hans Ganesh. The issue that the appellant is submitting to the board for consideration is at page 140 of the brief, namely, whether the appellant, in its capacity of employer of the respondent, liable in damages, injury sustained by the respondent while the respondent was from his place of work to his home in a car bearing registration number 47 G90. Grounds of appeal are at page 130. There are two approaches. The applicable contract of transport in this case. One by the Supreme Court at page 92 of the brief, lines 27 to 30. And the second one by the respondent, in that the respondent argues that this is a contract of transport against a background of an employer-employee relationship. And I here refer to paragraphs 4, page 154, paragraph 8, page 155, paragraph 31, page 162, paragraph 41, page 165 of the written case of the respondent. My lady and my lords, I will go through each approach to show the weakness of each approach. In doing so, I will be advancing the arguments in support of the appeal. Before that, I will very quickly refer to the consideration by the Supreme Court of the respondent's contract of employment. Before I turn to the contract of employment of the respondent and the applicable contract of transport, let me deal with the point made by the respondent, but the board should not upset concurrent findings of fact. The appellant is in agreement with that point. The appellant had a complaint at paragraph 27, page 146, as to whether document A, which is the application form for use of vehicles, can be taken to be the contract of transport in this case. Document A is at page 39.
Mr. Chetty, Lord Wilson has got a question. I think the problem is that you're giving us the page numbers for the electronic bundle, and those members of the board who are not using the electronic bundle need to have the page numbers for the particular document that you're referring to. Is that the problem?
Mr. Chetty, that is the problem. For example, when you said page 146, to what document were you referring?
I'm so sorry, my lord. Page 146 will be the written case of the respondent.
We have, of course, Ms. Deal's written case, but in my copy, there is no numbering other than the internal numbering which she has supplied, which goes from page 1 to page 15. So in respect of the written cases, would you be able to refer to paragraph numbers, please, or internal numbering, rather than the numbering which you are lucky enough to have?
I will, my lord, and I do apologize for this.
There's no need for an apology. Thank you very much.
The paragraph numbers will be fine.
Yes.
Yep. And I think you did refer to paragraphs 4 and 8 of the respondent's case.
4, 8, 31,
And 41.
and 41. I was on the document A, which is at page 39 of my brief. Which is document A, and it is the application form for the use of vehicles. And I'm referring to document A at this moment in the context of the point taken by the respondent that the board should not upset concurrent findings of fact, which I hasten to say that we are in agreement with. The appellant complained that this document cannot be taken to be the contract of transport in this case. This complaint can be seen to be a challenge of the finding of fact by the lower courts, but since the respondent accepts that document A cannot be considered to be the contract of transport, I respectfully submit that the appeal can proceed on the basis that the appellant is not asking the board to revisit findings of fact. I will come back later to document A in my submissions when considering the approach of the respondent to the applicable contract of transport. The argument by the appellant that document A is not the contract of transport is accepted by the respondent at paragraph 11, the last 4 lines of the written case of the respondent. And it is at page 156 for the briefs which have numbering. I will now, my lady and my lords, turn very quickly to the contract of employment. The judgment of the Supreme Court is at page 90. As regards the respondent's contract of employment, at page 91, lines 31 and 32, the Supreme Court takes note that it is agreed that the contract of employment of the respondent does not cover the present situation. We can also see from answer 2 to question 2 of the demand of particulars at page 13, lines 19 to 24, that the contract of employment did not contain a specific provision according to which the appellant had to provide the respondent transport to his home.
Sorry, could you give us the page reference again for what you've just referred to?
Page 13, 1-3,
1-3, thank you.
lines 19 to 24, and it's question 2, answer 2. So very quickly, the point is that the contract of employment does not apply at all to the present case. I will now turn to the two approaches as to the applicable contract of transport in this case. First, the approach of the Supreme Court. At page 92, lines 27 to 30, the Supreme Court addresses the question of the contract of transport and finds as follows. Quite clearly, we are not dealing with a normal and standard contract of transport between a passenger and the voiturier, vide Article 1779, Alinéa 2 of the Civil Code, upon which is imposed an obligation de résultat for the safe and sound conveyance of its passengers. My lady and my lords, I will make 4 propositions as regards this finding. First, as it is not the normal and standard contract of transport, the applicable contract of transport has to be an exceptional one. Secondly, the contract of transport that the Supreme Court excludes is object-oriented or result-oriented. It has an obligation de résultat, which is the safe and sound conveyance of its passengers. Therefore, the only contract of transport which remains is one which is means-oriented. That is, one which has an obligation moyen. One which has an obligation de moyen. In other words, the way the appellant comply with its obligation under this applicable contract is to put a vehicle at the disposal of a respondent. A contract which is result-oriented is covered by Article 1137, which is at page MS 179.
Article
1137.
1137.
That is right, Your Ladyship. At page MS 179. And my argument is that this is the type of contract which is oriented, which is object-oriented, which guarantees a particular result. And a contract which is means-oriented is covered by Article 1147,
I'm afraid,
which is
Mr. Chetty, the situation is that we do not have Article 1137 in our documents.
Your Ladyship, I'm very sorry for this. The brief that I have has the page number as MS 179.
No, all,
Perhaps Mr. Robin Lloyd, if Mr. Robin Lloyd can help.
I hope so. 179 has Article 1139 on it. We have been
Handwritten.
supplied.
It's handwritten.
It's all right. We have now been supplied.
Okay. So I will go back on that point.
Thank you.
The point being that the Supreme Court, when they said quite clearly, this is not the normal and standard contract of transport which has an obligation de résultat. Our submission is that it is not a contract which is object-oriented. And I was referring to Article 1137 of our Civil Code at page MS 179, which is object-oriented or result-oriented. And the word object is being used at the second line of the article. A contract, on the other hand, a contract which is means-oriented is covered by Article 1147, and this is at page MS 180. MS 180 is handwritten. Our submission is that since we are dealing with a contract which is means-oriented, compliance with the contract is achieved by putting the vehicle at the disposal of a respondent. And for completeness' sake, since 1925, the French professor René Demogue, D-E-M-O-G-U-E, in his works on Traité des obligations en général, wrote about this distinction between obligation de résultat et obligation de moyens. My third proposition is that when the Supreme Court excluded the contract of transport with an obligation de résultat for the safe and sound conveyance of the passenger from being the applicable contract, the Supreme Court did not articulate under what provision of the law the applicable contract of transport would fall. My fourth proposition, as it is a contract of transport without the obligation de résultat, the appellant would not incur any liability once the appellant provided a vehicle, the means of transport for the transportation of the respondent. I can obviously be asked the question as to whether the appellant did not have an added obligation to ensure that the driver of the car is a competent one. If I'm asked that question, my answers will be as follows. If we refer to page 165, paragraph 42 of the respondent's written case, the respondent argues that the situation would be different. It is paragraph 42 of the respondent's case. The respondent argues that the situation would be different if the appellant had hired a taxi and had paid for that taxi, and the taxi had an accident. So payment may make a difference in this case. I will now refer the board to page 111. Lines 17 to 19. It can be seen from the examination in chief that transport was a transport for payment. The question being asked is, therefore, for that transport, it was the University of Technology who would pay, and not you. And the answer is yes. And to that extent, the next question makes it a free transport for the respondent. So it is agreed, therefore, that if this is a paid transport, the employer's liability is excluded. Secondly, if the same obligation were to attach to a contract with an obligation de résultat, as with a contract with an obligation de moyens, then there would be no need for a distinction between the two types of contract. My third answer on the question of the competence of the driver is that the car belonged to Mr. Ramtoel, and it is for Mr. Ramtoel to see to it who is firstly allowed, according to his insurance policy, to drive the car, and who is competent to drive the car. And fourthly, in my submission, this is why the Supreme Court went on to see whether the transport fell within the course of employment. It is because of their finding that the transport fell within the course of employment that the Supreme Court concluded that the appellant incurred liability for this accident. And this was the only way, in the circumstances, to infer liability on the part of the appellant, and not by virtue of the contract of transport. From these four propositions, it is submitted that in law, the Supreme Court itself found that this is an exceptional contract of transport, which by its own definition and reasoning was means-oriented, and therefore compliance is achieved by the appellant by putting a vehicle, the means of transport, at the disposal of the respondent. I will now turn, with your permission, my lady and my lords, with to the approach taken by the respondent as to the applicable contract of transport. The respondent has it that this is a contract of transport against a background of employer-employee relationship. The respondent's arguments is that this contract of transport emanates from the general provisions of the law of contract under the Civil Code. There seems to be some support for that approach from the judgment of the Supreme Court at page 92, lines 31 and 32. The Supreme Court states, after having excluded the contract of transport under Article 1779, the Supreme Court goes on to state, here the employee has chosen to sue the employer for an alleged breach of contract based on a request for transportation, that is document A. I will identify 5 areas of difficulties with this approach. First, at page 156, which is the written case for the respondent, paragraph 11.
Sorry, could you give me that page reference again, please?
Page 156, Your Ladyship, paragraph 11. As
Paragraph
from
11.
line 5
Paragraph 11 of what?
The
of the written case of the respondent.
Yes. Well, we've
As from
seen that
line
before.
5, yes. As from line 5, therefore, the respondent accepts the appellant's contention that the application form, that is document A, is not contract. While the appellant is entitled to challenge the presentation of the respondent's case and the finding of the learned magistrate as to whether document A is a contract of transport or not, I humbly submit that the respondent cannot do so, inasmuch as the argument that document A is the contract of transport is a core element of the presentation of the case before the trial court and a core element of the judgment of the learned magistrate. Let me explain this. Senior counsel for the respondent before the trial court submitted that document A is the contract of transport. And this is at page 32.
30, 30, 30.
32, 3-2.
Thank you.
Lines 9 to 24. Learned senior counsel in submission says, this is approved. Have a look. Working beyond office hours. UTM Sebastopol Bel Air. Names of passengers. What more do you want? Isn't this a contract of transport? And at line 23, senior counsel submit. So the whole case rests on this document. The learned magistrate observes and finds as follows at page 35. As from lines 21. Counsel for the plaintiff relied on document A, produced which amounts to a contract of transport. And she goes on to further support her finding that this is indeed the contract of transport. And counsel for the respondent, on appeal before the Supreme Court, at page 86, lines 23 to 25, submitted that document A is what he termed to be a subcontract. And that is the same document A that we are talking about. My submission is that if senior counsel for the respondent argued that document A is the contract of transport, if the trial court has accepted that argument, and if counsel before the Supreme Court also referred to document A as being the contract or subcontract, then my submission is that it is an operative factor for the identification and establishment of the applicable contract of transport in this case. If now the respondent argues that document A is not the contract of transport, and there is an alternative source for the conclusion of the contract of transport, this alternative was neither presented before the trial court. The second area of difficulty is that at paragraph 12 of the respondent's written case, page 156, respondent states that Persian law does not require a contract of this kind to be in writing. Senior counsel for the respondent at trial stage made a similar statement at page 32, line 13. When he states a contract of transport is written. And if we turn to page 30, 1-3, lines 37 to 39, it's the demand of particulars. Question 5, answer 5. Answer is that the appellant provided respondent with transport according to a verbal arrangement, and probably there must be a record in the appellant's file. The proposition that this kind of contract does not need to be in writing is not quite correct. We will remember that for the second approach, we are within the provisions of a general contract, as opposed to a specific contract of employment under Article 1779. We will also remember that before the lower court, the respondent's case is that document A document A is the contract of transport. Under Article 1341 of our Civil Code, it is at page 181. Under Article 1341, a contract, which is termed here an instrument under private signatures, must be in writing. In case you don't have a writing, then you need what is called beginning of proof in writing in order to claim that there is a contract. The requirement for the beginning of proof in writing is as per Article 1347 at page 180. But if there is no written contract, but if there is a beginning of proof in writing, then you can claim there is a contract. Bearing in mind those two articles, 1341 and 1347, bearing in mind the specific words, beginning of proof in writing, commencement de preuve par écrit, we now understand the learned magistrate's judgment at page 35. Before the trial court, the contention of the respondent, then plaintiff, is that document A is the contract of transport. And there is an issue as to the terms and conditions as to that contract. And since the terms and conditions are uncertain, one way to resolve that uncertainty was to try to find a beginning of proof in writing. And this is why, in my submission, the learned magistrate at page 35 accepts that document A is the contract of transport and supports her decision as from line 29. Furthermore, the fact that it is stated working beyond office hours is in itself a commencement de preuve par écrit. That is, it is a beginning of proof in writing and clearly shows that the University of Technology accepted to provide transport for the employees who work beyond office hours. The learned magistrate, being alert to the potential defect of document A, supplements that defect by feeding into it a beginning of proof in writing. So to that extent, when it is said that there is no necessity for such a contract to be in writing, this is not quite correct a proposition. And any argument on the part of the respondent to the effect that the contract of transport is autonomous from document A, while at the same time supporting the judgments of the lower court, may seem contradictory. A contrario, the appellant can run the argument that document A is not the contract of transport because the appellant is challenging the judgments of the lower court. The learned magistrate of the trial court decided that the contents of document A, namely working beyond office hours, is a commencement de preuve par écrit in compliance with Article 1347 of the Civil Code. That being so, if now the respondent argues that the contract of transport is not document A, the particular applicable contract of transport has to be proved by writing by virtue of the same articles 1341 and 1347 of the Civil Code. For two reasons. First, because it is a contract, and secondly, because it would contradict document A. It would be again or beyond the context of the instrument, that is, outre et contre écrit. When document A says any vehicle, in one of the boxes it provides, it means any of the appellant vehicles. The contract as presented by the respondent contradicts document A, as it allows the use of the vehicle not belonging to the appellant to be driven by Mr. Ramtorel, an employee of the appellant, outside the scope of document A. And if reference is needed as to the ownership of the vehicle of Mr. Ramtorel, and as to the fact that Mr. Ramtorel is employed by the appellant, this is at page 30, 1.3, demand of particulars, question 4 and answer 4 of the demand of particulars. The third area of difficulties is that the Supreme Court stated that the normal and standard contract for transport is under Article 1779, and this is at page 92. There must therefore be a cogent reason why any court would find a contract of transport based on general provisions of the law of contract rather than on the specific provision of Article 1779. The more so, as our civil code is on contracts is organized in the following way. It has a title known as titre troisième, and it refers to des contrats ou des obligations conventionnelles en général. En général. Then there follows succeeding titles dealing with specific contracts, namely matrimonial contracts, sale of immovable properties, and under titre huitième, title number 8, it deals with contracts of transport, notably Article 1779. Hence the question, what is the compelling reason to abandon the specific provision in favor of a general provision? The fourth area of difficulties is this. This contract must be seen as an autonomous contract, having no link with the contract of employment. The employment relationship is used as a background only. For such a contract to come into existence, there must have been consent by the contracting party. And that consent must have been given by free will and by choice. Otherwise, it would have been a contract under duress. To that extent, the appellant cannot compel the respondent to travel in a car. If, for example, somebody certified that the brakes of the car were defective, it cannot be argued that nevertheless, the respondent would still be under an obligation to travel in that car. Similarly, if the respondent cannot be compelled to travel in a car if the driver is not a competent one. The fifth area of difficulties is that the respondent is in agreement with the appellant as the wrong application of the test in the case of Van Dyck against Fender by the Supreme Court. And this is at paragraph 34 of the respondent's page 163. Page 163. It is agreed that the Supreme Court erroneously applied the test in the case of Van Dyck against Fender, as it ignored there should have been an obligation on the part of the respondent by virtue of the terms of contract of employment with the appellant to travel in that vehicle. The contract of employment was not produced in evidence and we do not know its content. The above arguments, my lady and my lords, show that the appellant cannot in law be liable in this case. Secondly, the above arguments show that if ever there was a contract which came into existence, that contract is a vague one. The terms and conditions of that contract are unknown. The role played by the appellant, by the respondent, by Mr. Ramdoel, whose vehicle is being used and who is an employee of the appellant, are unknown. Therefore, on those premises, no liability can be inferred on the part of the appellant. My lady and my lords, I will also refer to the written case of the appellant. And my lady and my lords, these would be in essence my submissions to support the appeal. And I'm quite happy to answer any questions that the board may have for me.
Thank you very much indeed, Mr. Chetty. I don't think any of my lords have any questions, so thank you very much indeed. We'll now hear from Steele.
My lords, we say with great respect that the difficulty with the appellant's case is that it proceeds in written form and today on a simple misunderstanding, that this is not a claim that was brought by Mr. Gopeechand, by the respondent, based on an alleged breach of an employment contract. It's a claim that's founded on breach of a transportation contract. That the transportation contract would not have been made in the absence of the underlying employment contract is entirely true. But the contracts are not one and the same, and the obligations on the appellant were those of the provider of the transportation rather than those of an employer per se. So our response can respectfully be summarised Firstly, this was a claim for breach of a transportation contract. Secondly, the courts below rightly found that the contract was breached when the driver driving the car provided for that transport so drove as to cause injury to the respondent. Thirdly, with great caution and hesitation, we say that the Supreme Court may have been taken down a wrong path with the emphasis on Van Dijk and Fender and its application to employers' liability claims when the employer has agreed to provide transportation, but that is not necessary for you to determine in order to decide the appeal. Fourthly, in any event, there was enough evidence to support the Supreme Court's conclusion that to the extent the test of obligation in Van Dijk is the relevant one, it was satisfied. Now, of course, the background to all of this was the relationship of employer and employee. The respondent was entitled to expect transport home when he worked late, and so much was accepted before the Supreme Court by counsel, not Mr. Chetty, but by counsel for the appellant. If I can take your Lordship and your Lordships to page 73, this is the record of the submissions. Mr. Nasru was counsel for the university. In the first paragraph under his name, the UTM, of course is the appellant, provides to their employees who work beyond working hours transport facilities. So much is not in doubt. Now, on this occasion, the application was made on the respondent's behalf by Mr. Boscher on the appellant's standard form. And this is the form which you had referred to as Document A at page 39. And that is an application for use of UTM vehicles. Normally, according to the evidence that was given by Mr. Gopeechand at trial, the vehicles were coordinated by the office superintendent. And that's at page 116. This is the translation, the English translation, rather than the Creole version, which I shan't attempt to. At 116 and 117. At 32, answer, normally it's the office superintendent who effects the coordination for the vehicles. And then he says over the page in response to cross-examination that it's for UTM to decide the vehicles depending on the availability of which vehicle is available. And we can see from page 39 that the application was approved. Now that, in my submission, is the contract. Can you transport me home? Yes, on this occasion, we can. Not the document. The document is the proof of that an agreement had been reached. And nowhere in my respectful submission do either the magistrate or the Supreme Court say differently. There isn't.
Miss Deal, does it matter whether the document A is the contract? In other words, therefore, there's a written contract, or whether, as you are now saying, it is evidence of an oral contract?
In my submission, not at all. But of course it does matter on what the appellant is saying, because the appellant was making much play of whether this document A is the contract or is not. Now we say no, not at all. The agreement is the contract. The agreement, will you get me home? Yes, we will, is the arrangement. What document A does is that it confirms that a request for a UTM vehicle is made on the respondent's behalf and that the request is approved. The request is agreed to. To the extent that your lordships may consider that it is relevant to look into whether either of the lower courts were expressly saying document A is the contract, then in my submission none of them do. That simply isn't part of what they were saying. They were being invited to look at document A, of course. Document A was an important document. But they were not, either of the lower courts were deciding the case in my submission on the basis that document A and only document A was the contract. So the agreement, will you transport me home? Yes, we will. That fulfills in my submission all the necessary criteria for a contract under Mauritian law and set out in the written case. The relevant provisions, so we say, of the Civil Code, and they're in particular Articles 1101 and 1108, which are at pages 174 and 176. And what the appellant has done in my submission is it has agreed to transport Mr. Gopeechand home because it's his employer, but not as his employer. So that the employment relationship is what underlies all of this, but they're not one and the same. And then, of course, come the end of the working day, after 9 o'clock, a car is there with a driver to take Mr. Gopeechand and Mr. Bosher, his co-applicant, home. And Mr. Gopeechand confirmed in his evidence at trial that aside from the driver, it was only the two of them in the car, and that's at page 110. And of course we know that the driver is a university employee, he's a UTM employee. Now, as to the car in which travelled, and I worded it, I hope, quite carefully, that come the end of the working day, the car was there. I've addressed in my written case, and I don't understand that the principles are now in dispute regarding the concurrent findings of fact. Not going to labour the point, because of course a principle with which you are amply familiar. But what we would say is that both lower courts found that the vehicle in which the respondent was travelling was the one that was provided by the appellant in response to its agreement to provide transport home. It was the appellant's chosen vehicle to effect the transport. And the relevant references for the magistrate in the intermediate court are at page 35 and 36. And for the Supreme Court at pages 92 and 93. I think the line references are in the written case. So, yes, we can transport you home, and on this occasion, this is how we're going to do it. And we say, of course, that that was the obvious, indeed the only proper conclusion in the light of the pleaded case, and the relevant particulars are at pages 13 and 14, when the request for further information is being, or the request for further and better particulars is being completed. What Mr. Gopeechand said in evidence at page 110, the University of Technology provided with the transport. In order to obtain it, you have to make the application to be approved, yes. How many were in there? And then he sets it out. And going through on to 116, the thing that I've just made reference to, normally it's the office superintendent who effects the coordination. And then finally on 117, it's up to the UTM to decide, yes, UTM to decide the vehicle, depending on the availability of which vehicle is available. And of course, we would say there was no other explanation that was plausible. Was it mere coincidence that Mr. Ramhatal happened to be there offering to drive them home? Was he mere volunteer? No, of course not. There was no evidence to the contrary either way. So the factual scenario, which is the subject of the concurrent findings and on which this appeal therefore has to be considered, in my submission is this. The request was made and approved for a UTM vehicle. And what was provided was on that occasion a UTM vehicle and a UTM driver. And I would respectfully disagree with my learned friend. He said towards the end of his submissions that the roles played by the appellant and the respondent and Mr. Ramhotal are unknown. In my submission, they are absolutely clear. They were clear before the Intermediate Court, before the Supreme Court, and no challenge is possible now. Now, the contractual obligation is to effect that transport and transport him home safely. I find myself at something of a disadvantage. I don't have to hand the authority of the French professor regarding the contract of obligation versus the contract of means. And we don't have before us some of the provisions of the Civil Code to which Mr. Chetty was making reference, but nonetheless I will do the best that I can. What we say is the pleaded case was that the obligation on the university was to transfer Mr. Gopeechand home safe and sound. There was no consideration of that. There was no challenge to that beyond a simple, well, there wasn't a contract at all, before either the Intermediate Court or the Supreme Court. The learned magistrate expressly accepted at page 35, line looks about 36, hence the employer UTM was under a duty to provide a safe transport to the plaintiff as the latter worked overtime and the plaintiff was still under the employer's care until he reached his place. The Supreme Court upheld that. At page 94, we're therefore unable to say the learned magistrate came to the wrong conclusion when she concluded that the appellant was under a duty to provide a safe transport to the plaintiff, which it failed to do. So it's been at no stage any part of the case that the university was seeking to run, nor indeed, of course, is it part of its written case before this board, that some distinction can be made between the contract that was pleaded and accepted in Mauritius and a contract of means. This was a contract, we say, it was an obligation on the university to do something. It was an obligation to transport Mr. Gopeechand and indeed Mr. Boscher back to their homes. And that is what creates the obligation of result.
So, Ms. Deal, you're saying that the contract included a term which guaranteed the safe return of your client home, irrespective of the circumstances in which any accident might occur?
There may well be situations when you are placed under an obligation of result, you have to return them home safely, you are in breach of that, but nonetheless you are able to put up a defence because, in fact, there was absolutely nothing you can do about it. It was the exclusive fault of someone else. You might then be able to bring them in as what we would call Part 20 defendants. But on this occasion, the obligation was to transport Mr. Gopeechand home safe and sound. There is nothing, and I am simply not in a position to assist your lordship on any question as to whether there might be an implied term of reasonableness, such as would be more familiar to me, certainly. But that was the basis on which the case was run and accepted below. And it does leave us in a rather awkward position if now it's being said, well, actually, it's a totally different form of contract by reference to provisions of the Civil Code that haven't previously been brought to our attention and aren't in the bundle, to say, well, you can safely ignore that which was accepted below as to the obligation that was on the university. I can deal, and it's probably right that I should deal at this stage, with what was mentioned about the contract with the voiturier. That was not part of the case that Mr. Gopeechand was bringing, and the Supreme Court was entirely right in that regard, because as I understand it, and this is my submission, the driver would have been a voiturier under that relevant contract if there had been a contract between Mr. Gopeechand and Mr. Ramhatal. But of course there wasn't. There was no contract between him and the person who could have been the voiturier, which would have brought into play that relevant provision of the Civil Code. The contract was between Mr. Gopeechand and the university was not the voiturier. That is not a point that I can go much beyond, simply because we do not have Articles 1779 for us to look at.
But, I haven't seen 1179, but it's quite common in civilian systems for there to be an obligation of strict liability on a common carrier, and so whether or not the driver was a common carrier may be academic in this case, because you say the contract wasn't between him
Precisely.
and the passenger anyway.
Precisely.
But-
It might have been,
Yes.
had the case been run in a totally different way, it might have been
Yes. But
a way that the case could have been put.
I wonder, even if the contract, if it was a one-off contract between the two employees, I wonder if 1779 would apply, because that would not make him a common carrier.
No, I don't
But
think I
you
can go
need-
much beyond.
You don't need to go that far.
No, I don't think so.
Similarly, the question whether there was an absolute liability to get someone home safely, or whether there was an implied liability that the driver would exercise reasonable care, that is academic in this case, because the driver was found guilty of fault.
Absolutely.
That would not lead to any different result.
No, there would have been no additional benefit to the respondent, or indeed appellant, to be trying to drive into whether there was any reasonableness, or whether the driver could, or whether the university could have said, well, we're simply not responsible because he drove perfectly properly and his car was properly maintained, because everybody knew and accepted that on this occasion Mr. Ramhatal had not done that, because he had been fined and there'd been other consequences for him.
Yeah.
It may be a very interesting academic point for another case, but not one for this one, we would say.
No.
So could the case have been put, not in contract, but in tort? Could you have alleged that Mr. Ramhatal was the servant or agent of the university when driving the car, and that it was vicariously responsible for any negligence on his part towards your client?
That is something so much more familiar to those of us from this jurisdiction. In theory, as I understand it, yes, there is a slightly different way of approaching whether someone is what I understand, I'm sure Mr. Chachi will correct me if I'm wrong, may propose, which doesn't precisely equate to our concept of servant or agent. As I understand it, that might have been an option for pleading this case, but because it wasn't the way, in fact, for whatever reason, Mr. Gopeechand and those who represented him chose to put it, I haven't attempted to uphold the decision below on those alternative grounds.
No.
And I am sure that the university would have been extremely unhappy had I attempted to do so.
Yes,
it wouldn't be more familiar to my mindset, certainly, but I'm not seeking to uphold on that basis.
Well, no case of tort was pleaded. It's as simple as that.
Absolutely.
But you say you've pleaded a case of contract.
Yes.
And you say there was an obligation to transport him home, which was performed by a co-employee as agent of the of the university.
Yes.
And that whether it was a strict liability or an obligation to exercise care matters not in this case, because the driver drove badly.
Because the contractual obligation is, will you transport me home? Yes, I will. And it's what I've summarised in, again, looking at this from my English jurisdiction perspective as the photo production point, simply because it's encapsulated so beautifully by the passage from Lord Diplock, which is at page 380. But it is a principle that we say that both systems of law have in common, that if you contract, you are the one who is fixed with the obligation, and what has to be done, or you pay damages if it's not done. And how and by whom is essentially immaterial. And that made reference in the written case to the various provisions of the Civil Code, but in particular I would say Articles 1119, 1120 and 1142 underline the common approach between this jurisdiction and Mauritian jurisdiction, that if you contract to do something, you have to do it. The respondent expected the service to be provided, but might fairly be said to have been indifferent as to how the university chose to provide it. And on this occasion, how the appellant chose to provide it was by getting Mr. Ramtahal to do it on their behalf.
You say at the invitation of my Lord that it matters not whether the implied term was one of strict liability or one of providing a driver who would perform his duties with reasonable care. Well, it may matter not, but on which basis did the lower courts find that the contractual term existed? Was it a strict liability?
At page 35, this is the judgment of the magistrate in the intermediate court. What she, I think it's she, found 31, 2, 3, 4, the end of line 34, hence, the employer UTM was under a duty to provide a safe transport to the plaintiff as the latter worked overtime, and the plaintiff was still under the employer's care until he reached his place. And that is what the Supreme Court said they couldn't say that she was wrong at page 94. So, however one might otherwise have approached it, the basis on which it was put by Mr. Gopeechand, accepted by the magistrate and upheld by the Supreme Court, was that there was a duty to provide safe transport. And I would say again, my Lord, that this was not something that was the subject of challenge below.
No, I appreciate that. I just want to understand what is the actual basis of it. Is it strict liability, or is it a duty to provide a safe driver in the sense that he would drive competently and with due and reasonable care?
We would say it certainly goes beyond providing a car and a driver.
Yes, well, I think that is a given, yes.
And if the obligation is to provide transportation home, I mean, on any view, that didn't happen on this occasion because Mr. Gopeechand didn't reach his home for some time because he went to hospital. But I do have some difficulty, my Lord, because it wasn't the subject of any discussion below, and I feel like I'm treading on his ground, getting into what the precise obligation could have been, other than the basis on which it was put and accepted by the lower courts.
Yes,
and on the pleadings, it's absolutely plain.
Yes.
The claim form is on page 7, paragraph 6.
Yeah.
Says what the pleaded obligation was.
It's absolutely, say, safe and sound,
Yes.
which is...
And the defence, on page 17, denies, but it doesn't deny that.
Exactly.
It denies that the defendant was bound to provide transport under his contract of employment, and that the plaintiff was obliged by his contract of employment to travel in Mr. Hamtall's car. It does not deny that the obligation was...
There was a denial of a contract, not the denial of that term. There was no specific consideration of that term until the point that it was then accepted by the learned magistrate and then, of course, upheld by the Supreme Court. But it does perhaps underscore why we say that this is based really on a misunderstanding, that this is our case. It's a simple contract of transportation, get me home. And how things seem to have gone off down a slightly different, well, yes, but that wasn't within the contract of employment. No, we know, we don't care. The contract is what underlies why we came to you to ask you to transport us home. But transporting me home, because you owe me that duty as my employer to provide transport when I work late, but you're not transporting me home as my employer, you're transporting me home because you've agreed to transport me home. So my lady, that's precisely the point, that we seem to, the way in which the case is put doesn't seem to have been precisely addressed in that, but nonetheless, it was put on that basis and it was accepted on that basis, and I'm certainly not seeking to go behind that.
Now, Ms. Deal, was your client, was the court right to say that your client was obliged to take the lift in the car? Or do you say that it is unnecessary for your success that he should have been obliged to take the lift in the car?
My Lord, as I indicated, I hope with caution in my written case at the beginning, we consider that the Supreme Court may have gone off down the wrong route with the consideration of the Van Dyke and Fender obligation test, and that there was nothing about the contract of employment that was relevant to how he came to be in the vehicle and the obligations that may have arisen because he was in the vehicle. If there were to be consideration given, I say it's not necessary for the disposal of the appeal because the appeal is on the contract of, the proper analysis of the case is on the contract of transportation. But to the extent that you considered that it might be necessary to look in slightly more detail at the way in which the Supreme Court approached it with Van Dyke and Fender, we would say with hesitation that one might need input from the lower courts on that, because Van Dyke and Fender really has nothing to do with this case or this scenario, nor indeed do the Mauritian cases that follow it, because all of those cases, Van Dyke and Fender, Tufani, Mauritian Eagle, and there was one other as well, they all concern questions of which insurer is liable for the risk. They all concern situations when there is no dispute that the employee is liable to receive his damages. The question is it the employer's liability insurer or is it the road traffic insurer that is going to have to pick up the tab? Van Dyke and Fender, in my submission, cannot properly be stretched to cover a scenario where an employee, any employee, is claiming damages from an employer with or without a separate contract of transportation, such as we say we have here. We are not aware of any case, certainly not one that was put before the Supreme Court, where Van Dyke and Fender has been used to establish or to deny an employer's liability to its employee.
But there is no evidence that he was required to travel in the car.
I'm sorry.
There is no evidence that he was required to travel in the car.
Firstly, we would say don't need it at all, because that really is taking things off down the wrong route.
Yeah.
But to the extent that there is any requirement for obligation, there was enough, and your lordships and your ladyship might feel just enough to support the Supreme Court's conclusion that there was an obligation because there was an agreement on the part of the employer to transport the employee home.
Well, that doesn't sit easily with the circumstance that he had to apply to get the transport.
Well, my lord, that's precisely it, that he does have to apply. He puts in his request, and then they tell him, yes, it's been approved. The office superintendent coordinates the vehicles. The respondent said in response to the request, well, who told you where to go? Well, I can't remember, but I think it was the office superintendent. He goes to where he is told to go to, and he takes the car that he is told to take. He's not getting into any random vehicle that happens to be there. He is following, as one would expect of an employee, his employer's instructions as to what to do, because he has asked and they have agreed. It's not part of the normal working day.
Well, was it open to him not to apply?
I'm sorry?
Was it open to him not to apply?
Well, that was precisely one. It was certainly open to him not to apply. But once he had applied and the university had said, yes, approved, this is where you go, this is the car that you get into, and he has followed those instructions, as of course he did on this occasion, then in my submission we are into the question that the Supreme Court were entitled to say he was obliged to get into the car because he'd asked for it and they provided it for him. Now, in the Mauritian Eagle case, to which reference was made in the appellant's written case, it's at tab 12, which starts on 341. I would say, just to underscore the point that I said in response to my Lord Wilson, that this, as you can see from the first paragraph there, it's an appeal against the decision that the appellant, then the defendant in guarantee, was liable to indemnify for damages which the latter, the employer, admitted had to be paid. I mean, that underscores all of the Van Dyke run of cases, is that they're none of them about establishing the underlying liability, it's about the insurance.
So just looking at the title, Miss Deal, Mauritian Eagle were the appellant. They, I think, were the motor insurers.
Yes.
They would be liable if he wasn't acting in the course of his employment.
Yes.
Number two, Swan Insurance, were they the employer's liability insurers? And were they liable if he was acting in the course of his employment?
Yes, so it's a scrap between insurers.
Yes.
Whose policy is it falling under? And this is, so you can see at page 342 at the bottom that reference is made to Van Dyke, because that's what Van Dyke is aimed at. Van Dyke is aimed at sorting out who is picking up the risk, not who's paying who's responsible for the damages to the injured person. And at the top of page 343 is the section of the judgment from Lord Denning about the emphasis on the obligation. And in this one case, which is relied on by the appellant in the written case, there were a number of factors that were taken to support why it was not possible to say that the injured person was obliged to get into this vehicle. It was conceded by learned counsel, this is about two-thirds of the way down 343, that failure on the part of the third respondent to use the minibus would have had no consequence on the contract of employment, a concession which speaks volumes in favour of the absence of any obligation on the part of the third respondent or any corresponding right on the part of the first respondent. Moreover, when the first respondent was pressed by a demand of further and better particulars to state whether in the terms of her contract of employment she was under any obligation to travel in the minibus, the latter only gave a vague answer which did not address the question asked, shows again there was no such obligation. And then moving to the bottom line, as correctly found by the learned judge, if the first respondent was under a legal obligation to provide free means of transport, and then there's reference made to a set of regulations which don't apply in this case. And then, indeed, as correctly observed by the learned judge, it would be inconceivable to hold that the third respondent was obliged by her terms of employment to travel in the minibus of her employer after work and not, for instance, take a lift or decide instead of taking the bus to visit a friend and go home later in her friend's car. no doubt in that case, entirely relevant features and all based on the evidence at trial. Now, in this case, the university chose to adduce no evidence of its own. The further and better particulars didn't address the questions that Mauritian Eagle considered to be relevant, and the questions that were put in cross-examination to Mr. Gopeechand didn't address that either. So although in the Mauritian Eagle there was sufficient there to say, well, there's no obligation. You can't properly say you were obliged to travel in the minibus as it was in that case. In my submission, it doesn't lie in the appellant's mouth, and particularly not at this stage, to say, well, you can't make out the obligation because they chose not to adduce the evidence or even to try to adduce the evidence, which was determinative in the Mauritian Eagle case on which they were seeking to rely. So, no, I would say that the question that my Lord Wilson raised, was he obliged to get into the car, I don't accept, with great respect to the Supreme Court, who of course were presented with this as an agreement between the parties that this was the relevant test, but I don't accept that obligation under the contract of employment to travel in the car was the relevant test for the purposes of this scenario. But if it was the relevant test, or even a relevant test, then there was just about sufficient for the Supreme Court not to be overruled by this board to say, yes, he was obliged to get into it, because he asked, they provided, and he followed their instructions as to where to go. And if the appellant wanted to add a little bit of flesh to the bones, as it were, and have something that would have underscored why there really was no obligation, then it behoved them to do it at first instance and not to seek to say before the Supreme Court or indeed here, well, there was nothing to show obligation. That they had every opportunity to show that there was no obligation because there were alternatives, because the contract didn't provide for it, because nothing bad would have happened to Mr. Gopeechand if he simply hadn't turned up at 9 o'clock and had gone about his business his own way. And because they chose and elected not to do that, then in my submission they can't then effectively hold that against Mr. Gopeechand at this stage. I did, to the extent that there is any interest in exploring the Van Dijk and Fender point. So I'm dealing with this cautiously. If it were to be said that Mauritian law is such that when an employee seeks to bring a claim against an employer, other than under the terms of the Workmen's Compensation Ordinance, which as I understand it still applies in Mauritius to certain cases, albeit not to Mr. Gopeechand because he earned too much, if it applies more generally outside workmen's compensation cases, then it's something in which respect might need to be given to the local courts to ask for their input on what is, of course, their area of law.
Well, that case hasn't been made, as I understand it.
It's what, sorry?
That case has not been made, as I understand it.
Well, there is the difficulty that I have to accept that the way that it was put below was on agreement that the relevant test was the Van Dijk and Fender test. Now, so I simply don't accept that. It's not. It's a contract of transportation based on a contract of employment. It's not something that requires an analysis of whether Mr. Gopeechand was in the course of his employment. It might be rather more relevant to the question that my Lord Wilson raised earlier about bringing a claim in tort as to whether Mr. Ramhadar was in the course of his employment, but that's not what we're addressing.
Well, actually, we needn't go back because it's a sideshow, but I think almost the first paragraph of Lord Denning's judgment makes quite clear that the driver supplied by the employers was an agent of the employer for that purpose.
Yes, it did. But in Van Dijk, what was also clear from the judgment, if I got the relevant reference to it. At
I think I was
415.
thinking of page 415.
Yes.
Section 3. If you've got that
Yes.
to hand, Miss Deal.
Yeah.
Mr. Fender was not a paid driver. He was not driving this car as the servant of the Reddington Company. He was driving it for their purposes, so as to bring himself and his fellow employees into their work. He was the agent of the Reddington Company,
Yes.
therefore they're liable for his negligence.
Precisely. That there was no, Van Dijk was not employee getting damages of employer. That wasn't in dispute. It wasn't in dispute in Mauritian Eagle. It
No,
wasn't in
quite.
dispute in Tiffany. This line of obligation, course of employment, comes about between insurers having a spat as to who should pick up the tab, not, as in this case.
Well, you've made that point.
Yes.
We understand it.
I'm grateful. The only reason why I'd raised that was the extent to which you might... this was the basis on which the board, on which the Supreme Court found, admittedly for the respondent, it was, we consider, on the basis of having been led astray by the agreement that this was the relevant test. But the more important point, we say, is that it simply isn't relevant for the determination of this appeal, that there actually isn't a need to go into whether this is a relevant test under Mauritian law, whether it is relevant to the question of employee versus employer, because in this case it's nothing more, nothing less than a contract of transportation, and the obligations would have been no more and no less on the university, whether it was his employer that night or not. I think, unless there's anything further.
No, Miss Deal, I think not. Thank you very much indeed. Mr. Chetty?
My lady and my lords, I have no reply to make following the submissions of my learned friend Miss Deal, but if I have questions to answer, I will do so.
Thank you very much indeed. Their Lordships have no further questions. We're very grateful for the submissions that we have received, and we will now take time to consider our judgment. The board will now adjourn.